So it's great to avoid probate with a great estate plan. However, many times there's disputes that arise in the process and can actually become litigation. One of the local attorneys who litigate and or handle such disputes is Nicholas Van Brunt. He's with SheppardMullin here in Los Angeles. Nicholas, thank you for spending time with us today.
Yeah, thanks, Bill. You can call me Nick.
So thanks, Nick. So give me an idea how do you get into this particular specialization of disputes and litigation regarding estate planning and trust administration?
Yeah, it's interesting. So I started my career at a large law firm doing large commercial litigation matters. There's a small company known as Enron that you may recall, and I was
Yeah.
in that litigation, and it was super interesting. But I knew pretty early on that I'm the kind of person that, as a lawyer, just finds it more interesting the more interesting the story is. And while there was definitely an interesting aspect to large securities litigation, the stories are more interesting in the trust and estates world. And so I actually got a recruiter call after pulling an all-nighter reviewing documents. And at first I said, I really don't know anything about trust and estates, but I'll go on the interview. And I met with my now partner, then mentor, Adam Streisand, and he convinced me to do it. And I figured, okay, this is something I can do until I pay off my student loans. And now it's been, I don't know, 18 years since then. So
Wow. Wow.
yeah.
So one of the most common misconceptions I get from people is that an estate plan and a trust will avoid litigation in court. And the reality is it reduces the odds, I would imagine, or improves your prospects. But I always tell people, so my father was an attorney, taught me, which is anybody can sue anybody for anything. So what percentage, if you were to guess, what percentage of large estate plans, despite all the paperwork, end up with some sort of dispute and or litigation to it, do you think?
Geez, I don't know the percentage. I would say the majority of estate plans avoid finding their way on my desk or the desk of people who do what I do. But just because you have a sophisticated estate plan does not mean you will avoid court. It certainly will reduce it. I mean, you're guaranteeing almost that you'll go to court if you don't have an estate plan. But the issues range from, did grandma or grandpa know what they were doing when they signed the estate plan? Were they susceptible to undue influence? Were they defrauded into it? And then even if there's no issues with the document itself, did the person who's was appointed as executor or trustee, are they taking actions that are conflicts of interest? Are they making decisions that are inappropriate? And so that stuff can come up. Now, the way that you draft an estate plan can help you to reduce that risk, and the more sophisticated your estate planner is, usually there's a direct relationship between their level of sophistication and the ability to put things in to avoid or disincentivize litigation. But there's no foolproof. As your father said, anybody can sue anybody for anything.
And these days, I think they do. I think it's a
Yeah,
lot
it feels
worse.
like it. Feels like
So, what percentage of your time is spent defending estates that have plans in place and administering it, and there's issues there, versus, say, attacking it from the perspective of the left out son or the family that feels that the beneficiary was taken advantage of?
yeah.
How does that line up for you? Defense, offense, plaintiff versus defendant? How does that work out for you?
Yeah, no, that's a great question. I'd say the majority, though it's not like a massive majority, is probably on the defense side. But I definitely have brought my share of contests to trust instruments. I've brought my share of cases against trustees for breaching their fiduciary duties, but more often than not, we're on the defense side, probably.
And when you say on the defense, what approximate percentage of your cases are your own estates that you're defending versus maybe they got it done somewhere else and there is a defect or they left the door open and
Uh,
your job is to try to close it or fix it after the fact?
usually it's somebody else, some other firm has done the estate plan. Not always, but you have to be very careful with conflicts of interest. And a lot of times the estate planning lawyer is going to be one of the main witnesses in the case. So if that estate planning
Ah,
lawyer is your partner, it becomes complicated. It happens, and there are circumstances where it's appropriate, but usually it's somebody else who's done the estate plan, some other firm.
So when you see estate plans that come to you and they're being attacked and they have some sort of a defect or mistake or something that was missed, what are the most common things that are missed or could be done, or barn doors that could have been closed if you go back in time?
Just some basic things. I mean, number one, including things like a no contest clause, which is a clause that says if you bring a contest against this, you'll be disinherited. Um, those clauses don't have a ton of teeth these days, but they still can disincentivize litigation, but they don't work very well if you've also disinherited the person in the estate planning instrument, because if they're going to lose $0, there's not much,
Right.
the way to do that. You can do things in the instrument to um, also protect the instrument, such as you can put language in there that says, hey, the trustee can use the assets of the trust to defend um, the instrument. And sometimes that'll help, because then, a beneficiary, if they have an interest in it, will realize, well, wait a minute, if I'm contesting this instrument, part of my inheritance may be used up for that purpose, and people will exclude that. The biggest thing I see actually doesn't have as much to do with the drafting. And this is where, your clients may be more interested. It's not having the conversations with your family before the estate plan is done. That's the number one driver of discord. If everybody knows what's happening ahead of time, if you have a family meeting, again, anybody can sue anyone for anything, but it makes it much harder,
Right.
right? Because then everybody kind of knows what the situation is. And it's an uncomfortable conversation. People don't want to contemplate their death. People are conflict avoidant, but that a lot of the time leads to the discord that I see, is when people are surprised.
It just seems to me as an outsider that people play out their family dynamics in court if they don't get a chance to do it in real life.
Right.
And if you can do it in real life, you kind of dissipate. I know my experience, acting sometimes as a representing a temporary administrator or uh, you know intermediary of some sort, that the more I can talk to both sides, I feel like I'm just taking some of the oxygen out of the balloon, so it's not quite so tight.
Yeah.
um, so that brings me to the next question, which is, obviously you're skilled, you're educated, you work on that regularly, but at the same time, I'm sure some of your success in business is based on soft skills, which is communication, gaining trust, working with getting trust of the other party's attorney. So how would you balance that out, and how do you look at that as you build your career on the focus? How much is it being right, and how much of it is convincing them that maybe they're not right?
Right. That's a really great question. So I'm gonna get to the answer in a little bit of a roundabout way. Um, when you're a litigator, when you're a lawyer, you have to litigate according to what your personality is, right? Some people are bulldogs, some people are, that's not how I am. I'm kind of solutions oriented. Like, hey, if there's a way to resolve this before going to trial, as much as I like being in trial, and I'm in trial a fair amount, it's always better for the family to save the legal fees. Not always, almost always better to resolve it, short of trial. And so where the soft skills come in is, you're an advocate in the courtroom. When you're talking to opposing counsel, you're still an advocate, but you're also you're a deal maker too, right? Ideally, depending on what your client authorizes. And I think being intellectually honest. And so you don't make every single argument, no matter how meritorious it is, because you're just firing a shotgun or throwing spaghetti against the wall and seeing what sticks. You need to actually be able to credibly defend, sort of, hey, I understand your point over here, but you haven't considered this, and here's why this matters. And so making a concession at the right time, showing that you have compassion even for the person on the other side, all of that comes into the mix. So yeah, it's soft skills, just being a normal human being, along with being a lawyer. I think that's been helpful to my success, certainly.
How much of your business is, now you're obviously with I don't know how you describe it, to me, large firm, substantial firm at a
Yeah,
minimum.
sure.
So you guys have a whole world of other businesses that I imagine generate business. That's the whole nature of firms as you're trying to generate
Right.
to some degree business for each other. Do you also get do business with other firms? Do you find, I mean, other attorneys, like you meet them in
Yeah.
probate case and they draft it, they're getting sued and they turn to you. How do you manage that? How do you develop that kind of business and that kind of reputation with your colleagues to generate that business?
So, one of the things that I do is try to be involved in thought leadership, meaning speaking, being involved in writing, and member of various bar associations, on executive committees, where you get to meet other lawyers up and down the state, or in some cases, in other states, and that's how you build trust with other people, so that they know who you are, and you try to just keep in touch, right? So that people remember who you are, where it's like, oh, this issue came up, I'm going to call Nick and two other people and see, who has a conflict, who can handle it, whatever. So that's, in terms of the outside, that's a pretty fertile network for me. And then honestly, I get a decent amount of referrals from lawyers I've been up against in the past, and vice versa. I've given referrals to lawyers I've been up against because I respect them. I mean, what better way to learn about how good a lawyer is when you're, it's like a basketball player, like when you're on the court, right? And for those of us who are not athletic, we practice law, but it's same idea. And then internally, obviously, yeah, as you identified, there's internal referrals that we get because we have a very diversified practice.
I think clients, having been with myself, the one
Yeah,
thing that aggravates them is how nice it seems like the opposing attorneys are,
yeah,
right? And I think judges expect and they probably demand that, right? They want a courtroom that's as relaxed as can be in a tough situation. They don't want sparks flying and outbursts that are unnecessary. And I don't think clients would appreciate that's the decorum of a courtroom, but it also extends over outside that. Like you say, you're meeting colleagues at bar events and other events and things like that. And that's what moves. How important is that? How do you make sure you're not letting your guard down? Because I have
sure.
the same challenge as a real estate agent, right? On one hand, I want to get along with the other party's agent. It's my job as a listing agent to sell the house, make them love me, make them think the house is great. But then when it comes time negotiations, sometimes I have to play with sharp elbows. So how do you kind of manage that process at the same time and not have a conflicted interest that your job primarily is with your client?
Right. So I'm very clear with my clients at the outset that the probate community is relatively small. If I know the lawyer on the other side, sometimes you already know who the lawyer is can be on the other side. I tell them whether I know that person or not, what my relationship is like with them. And I'm very clear that, if you want a fire breather who is gonna, just fight every issue, I've got a metaphorical Rolodex full of those people. My approach is to advocate vigorously for you, but I'm going to do it in a, I hope, dignified way, right? And
Right.
so I just try to set the expectation up front. But yeah, sure, clients like, why are you being so nice, or why are you educating, the other side? You explain it, and not every client is for every lawyer.
I go back to the days when you watch football games and the opposing teams would never cross midfield and shake hands. Nowadays, they're all friends, they're all in businesses together. And
Yeah,
to some degree, as a client, when you see the attorneys, shaking hands and chatting about the event they're just at, I think sometimes if they don't have those expectations set, it can set them off. And I think the key thing you said is what I see is not setting the expectations, the soft skills of running a business versus maybe the hard skill of just being an attorney.
right.
And it just seems like 90% of the times customers complain to me about an attorney, it's those soft skills that it's an extra phone call or an extra text or an extra sentence in the email to soften the blow that makes the difference in it. So
100%. Yeah,
so along the way, obviously your business is primarily on the legal, and I don't think sometimes real estate agents understand how much non-real estate there is in a probate, whether it be not just the assets, being the
sure.
only assets is real estate, just all the legal stuff, the accounting, the objections, the paperwork and such.
Yeah.
And yet inevitably, I know you come across real estate agents you work with. What are some of the best practices and what are some of the biggest mistakes you see amongst real estate agents as you interact with them on your litigation?
Well, I mean, the best practices, particularly, for a real estate agent that's in the probate world, is to have a working knowledge of the probate code. You're not expected to be a lawyer, I mean, that's why the lawyers are involved, but understanding how a court sale works, right? If it's out of probate, there's a lot of rules that go into that. A lot of things you have to do at the front end to make sure that it's going to get approved by the court. And so having that knowledge set, I think, is really important. And even with respect to trusts, there's all sorts of thorny issues that can come up with financing involving particularly an irrevocable trust, right? And so having some working knowledge of that, I think, is really important in terms of mistakes I've seen. Um, I mean, and I don't think this is just in the world of probate, but real estate agents can sometimes represent both sides of a transaction. That can really be problematic in a probate situation, particularly if there's, you know, people that are warring with one another, and particularly if the sale may not even be arm's length because it's with one of the beneficiaries. I've seen problems there. And even where I've seen situations where a real estate agent is representing one side, but in service of trying to get the deal done, even if it's not for the best interests of their client, will make disclosures to the other side that are really inappropriate just to try to get the deal done. So I've seen that happen too. And so
Mhm.
it's the avoidance of conflict of interest. That's the number one issue that I do see. And obviously the rules are different for realtors and lawyers in that respect. But yeah.
Well, and that's when I started real estate, I couldn't believe that you could double end the deal. Well, how does that even work? I signed a
Right.
contract with a seller and see I'm getting top dollar for his house. And they're gonna turn around and get a buyer to buy the house. How does that even work? I still don't even know. Occasionally, I'll say on a probate when like maybe there's like a $10,000 lot where no other agent wants to represent a buyer on that. That's a different story.
Sure.
I've also been hired by petitioners who wanted me to list the property and wanted me to represent them to buy it. And that's what they wanted. They're objectors. We went to court, we got it through, and nobody overbid it or whatever. And I did my job. But those are very rare. I don't understand how agents can regularly double in deals and pretend to avoid a conflict of interest. I can you imagine
Yeah.
attorneys if they could handle both sides of a conflict, what that would be like.
No, well, yeah. I mean, and in that, I mean, you can get a waiver under certain circumstances, but it's harrowing, right?
I would think. I would
Yeah,
think.
yeah,
Let's talk about capacity issues. I think we as realtors deal with this more, maybe that not so much in the probate sense, but just in general, the people end up, in some litigation down the road or probate. But, people throw around terms about dementia or aging and such. And yet as real estate agents, we often are dealing with those decisions and we want to support our clients. At the same time, we want to make sure we're supporting them properly. You must similarly have the backside when the mistake is made. Didn't you know grandma was past that point? So for example, take out the litigation side of it, just advising a real estate agent. What are things that you look at that you've seen that you say you should have noticed that or you should have seen that? Signature changes, is that alone? Is it, talking to them? What do you think are some of the key mistakes that you've seen people make doing business with elderly or people who are suffering from some advanced health issues?
yeah. And it's a really interesting question, and I don't want to suggest that real estate agents have a duty to evaluate the capacity of an individual. Even lawyers, technically, I mean, although the law is kind of murky on it. I mean, we're not doctors, right? We're not giving medical opinions, so there's an element of common sense. But if grandson is dragging grandma in to sign and she doesn't remember his name, and she doesn't really know, it's clear she doesn't really know what she's signing when she comes in to sign the escrow documents or whatever. I mean, that should be a red flag for you. Uh, Certainly changes in signatures. Again, I mean, you're not a handwriting expert, but if it looks really suspicious to you, that's something that should be a red flag. Maybe I don't want this in my life. Even if I'm not doing anything wrong, I don't want to have to lose a day of work to go testify at a deposition
No.
about it. And so those are the kinds of things but on some level, I mean, it's like anything else. It's you kind of know it when you see it, right? Financial elder abuse, capacity issues, you kind of know it. And so
I
it's
think
just use
so.
that
I
common
think so.
sense. Yeah.
I think that I think that's a fair way of putting it. I think sometimes we lie to ourselves because we want the deal. And we have to not lie to ourselves and just say, you know what you're looking at, and does it look right or not? I think that's a good
Right.
way to put it.
Yeah.
Um, so a little bit about trusts where the documents are missing, because I get the
Huh.
phone calls. I don't know where it ends up, if it gets to your desk or not, but I get phone calls where the property is in a trust, and yet nobody can find the documents.
Yeah.
And so there must be a range of options in those cases, right? What's the
Yeah, that's a big hypothetical. I've litigated those issues, and I gotta be a little careful because I'm litigating one of those issues right now. But as a general proposition, um, whether or not the physical trust instrument still exists is not dispositive, right? So to have a trust in California, there are various elements that you need, including without limitation, that there's trust property, that there's a trust purpose, that there's a beneficiary, there's a trustee. Um, but yeah, I mean, if you're getting involved in a transaction and nobody can point to the operative instrument, and nobody has even like a certification of trustee signed under penalty of perjury saying I have the authority to act on behalf of this trust, that should be a red flag for you, for sure.
and so now I would think you have to go back to court and get some sort of authorization. There must be some
Yeah,
petition to put it in the
yeah.
trust or probate it. Those are your two options, I think.
Yeah, no, I had a case that this is resolved, so I can sort of talk about it in generalities. The my client was appointed as an interim trustee where the issue was that there clearly was a trust because the property was titled in the name of the trust, but no one could find the instrument. And then, one side, of course, wants the trust to exist, the other side doesn't.
Of course.
And so they ended up settling it, and then based on that settlement, the issue of the determination of the trust was resolved, and you had a court order you could point to at that point, right? But it's yeah, a lot of times in that type of situation, the court's going to have to get involved, even if it's not litigated, just to either confirm the existence of the trust, or if not, to confirm that it's belongs to an estate.
Having the nuts and bolts here in LA County, I've had cases where people um, want to file a petition, maybe a Hegstead petition,
Sure.
spouse situation, or something related. And yet I know that if you file today, your court date's 6 months out versus a probate, you can get a hearing in 30 days, and then you have a creditor period. You can almost close a probate by the time you could finish the Hegstead petition, if not sooner. Do you see that as a viable solution, or is there a faster way to move things that I don't think the court wants to do faster cases just because you want to sell the house, unless there's something
Right.
compelling, they're not going to expedite it for you, I don't think.
Well, that's true. I mean, you're gonna have, no matter what, to get something expedited, you're gonna have to demonstrate irreparable harm, right? Delay is not irreparable harm usually, unless there's some sort of circumstance that can't be fixed. I don't know that Hagsteads currently are taking 6 months. I'm seeing trust petitions get set a little sooner than that. That definitely has been the case in the past. And I don't know that I've seen too many probates that wrap up in 6 months. So I think on average, a Hagstead's still going to be, if really the only issue is you had a pour over will, i.e. a will where the only beneficiary is the trustee or the trustee of the trust, and just the titling issue where it didn't get moved into that trust, and the trust shows that there was an intention to put it in the trust. Still probably faster to take that route if you can, if the facts are there, than to go through a probate. Because with probate, at minimum, yeah, sure, you'll get set within 30 days, but then assuming you get through the thicket of potential probate notes, which are defects raised by the court and don't get continued for 4 or 8 weeks, then it takes a little while to get the papers that say that you're the
Letters and
executor. Then you have
bond.
to wait 120 days because you have to give notice to creditors. Then you got to file an inventory and appraisal, and you got to file a petition. It could take it. It's to get it in under a year is pretty rare.
Well, you're 100% right. I think in a simple probate with a firm that like a mill that does probates regularly, it's doable. That a standard attorney is just not going to take. It's going to be longer than a year. I mean,
Yeah.
you describe all the different obstacles that they seem to trip over regularly, and it is a very detailed, particular process with unforeseen challenges. So definitely neat. Well, look, I really appreciate your time. I know I've got a little bit long, but I really
No,
enjoyed
that's okay. That's fun.
our time today. And if somebody wanted to reach out to you, if they had a particular trust in particular, or estate plan that they had concerns with, objections to,
Yeah.
or they had one that they were being objected to, or maybe even file a lawsuit against them on some sort, they want to reach out to you, what's the best way for them to reach you?
So my email address is nvanbrunt, NVANBRUNT at SheppardMullin.com. It'll take 2 minutes to spell it, but it's SheppardMullin.com. I'm also on LinkedIn, just under, I think, under Nicholas Van Brunt.
We'll
And
put that in the description down below and a link to your
yeah,
page on your website with all your
yeah,
social
and then the
media info.
website has my phone number and all that. So, yeah.
And you're located here in Century City?
I'm actually in Los Angeles downtown. I was
Oh,
in the Century City office for years, but I live closer to downtown, so I decided I wanted to see my kids for dinner, and so I moved to the downtown office during the pandemic.
oh,
So
nice. Okay. Well, I'll put the information in the description. Thank you so much for your time today. I really appreciate it.
yeah, it was great to meet you. Thank you so much, Bill.